There ain't nothing more powerful than the odor of mendacity.
And good evening, everyone. Welcome back Inside the Law. I'm your host, Philip Holloway. I want to start out by saying to all the dads out there, I hope you've all had a wonderful Father's Day. And for everyone else, I hope you've just had a wonderful weekend. And I appreciate you spending just a small part of it with us here Inside the Law. I can see even before the show started that the chat room is absolutely on fire. You guys are just absolutely killing it. I'm enjoying watching the comments and seeing the questions. Please keep that up. Tonight we're going to take a rather in-depth look at a lawsuit filed by the Merchant Law Firm PC, which of course is Ashleigh Merchant's law firm. She had to sue and is suing, I guess, the Fulton County DA's office in Fulton County over what they say are violations of Georgia's open records law as it pertains to Ashleigh's now famous quest to uncover information regarding how the district attorney's office spends its money and on whom and in what way. Before we get into that, though, I wanted to take just a minute I want to share with you something that, well, just take a look for yourself. This is something that someone named Rob forwarded to me, and I posted it on my X Twitter feed here. Today, this is apparently the Fani Willis campaign text. And as I point out, the words attacked and over-sexualized and stand in solidarity with Black women in positions of power. These things have apparently been poll tested as effective, it seems. And let's just take a look at this. It says, this is Fulton County DA Fani Willis. And I just said something I needed to get off my chest. Too often in America, Black women, especially those of us put into positions of power by the people, are attacked and over-sexualized just for doing the job we were elected to do. As I continue to do my job and seek re-election in 2024 as Fulton County District Attorney amid disingenuous attacks from the right-wing media, harassment, and regular death threats, I do sometimes stop and wonder, would all of this abuse and vitriol be coming my way if I were a white man? Rob, I need to know. Can I count on you to help me stand up to these daily attacks in my re-election fight against a right-wing opponent? If you will stand with me and stand in solidarity with Black women in positions of power, please donate any amount here. And you can see there in that link there, it's essentially, it says, protect Black women. So this is the state of the campaign, folks. This is the state of the campaign for the district attorney's office here in Atlanta, Georgia. Welcome to all 1,180 some odd people who are here live. This is Inside the Law. This is where we take you inside the real justice system. We use cases and issues that are currently in the news as the mechanism by which we show you the real workings of the real justice system, because it's not the one that you may think that we have from watching TV or the news. So take just a minute to hit the like button if you don't mind. It helps the algorithm to help other people find this channel, people who may have an intellectual curiosity or just may want to know what the real system is like. So thank you all very much, and we will be checking in on the chat. I am happy to try to answer questions as I go along, but do me a favor. If you haven't, go ahead and hit that like button. All right. The other thing that I wanted to point out before we get into this lawsuit, a couple of days ago, I did a video, a live stream, and it was over an hour long, and it was about this young thug, the YSL, which is another Fani Willis case. It's another Fani Willis racketeering case. And we had, of course, the issue of one of the defense lawyers being, cited for contempt. And Ashleigh Merchant went down and represented him, and then got an emergency application before the state Supreme Court, which, put a stay on it. So he did not have to spend Father's Day weekend in jail. But the issue was really whether the judge had, in fact, engaged in some type of improper, what we call ex parte communication. So what I did is I cut that down. I cut that hour and a half down to something that was more along the lines of 12 minutes. And so if you haven't seen it yet, just go look right here. This is the most recent video. It's called "The Fani Willis versus Young Thug YSL Trial Should Be Removed." It's 12 minutes long. Check it out. And I'm asking you to check it out because I need you to help me pay for it. I'm not good with editing. I'm not good with tech stuff at all. So I had to hire a professional who did a wonderful job, I might add. But do me a favor. Help me pay for it just by going and watching it. Okay. And that's all I'm going to say about that. All right. So here we go. Let's go ahead and bring up, if we can. Let me bring up the lawsuit that, and look, I mean, this thing is the whole thing is over 100 pages long, but the relevant portions of it are not. So that's the good news. Let's make it a little bit larger. Okay. You see, this is a lawsuit filed in the Superior Court of Fulton County. And by the way, one of the reasons that I'm doing this now is later this month, I think it's on the 25th, there is going to be a court hearing in Fulton County on this lawsuit. Okay. And so this lawsuit provides a lot of details it explains a lot of what Ashleigh Merchant did when she was investigating the allegations, which of course proved to be true, that Willis was having the affair with her paramour, Nathan Wade. And the allegations were, of course, that she personally benefited monetarily by virtue of him spending some of the money that he was being paid to take her all around the world on romantic getaways and that sort of thing. So it was a conflict of interest. And that, of course, is now the basis of the appeal that's pending before the Georgia Court of Appeals, whereby the 6 or 7 of the defendants are seeking to have Willis disqualified and removed from the case. And in fact, they're seeking to have the entire indictment dismissed on the basis of the conflict of interest. So this provides some interesting backstory, but it's also relevant because we've got a court hearing that's coming up. All right. So let me just go over this with you, if I can find it. All right. So this is the Superior Court of Fulton County. And we have the plaintiff is the Merchant Law Firm PC. That's the business entity that she operates out of against the Fulton County DA's office. And it's called a complaint for violation of Georgia's Open Records Act and motion for defendant to show cause. The introduction here says the Georgia's Open Records Act is the important mechanism by which citizens of Georgia are able to evaluate their government's use of resources, and that includes prosecutors. They are the government. The Georgia General Assembly explained the purpose of the act. The General Assembly finds and declares that the strong public policy of this state is in favor of open government, and that open government is essential to a free, open, and democratic society, and that public access to public records should be encouraged to foster confidence in government, and so that the public can evaluate the expenditure of public funds and the efficient and proper functioning of its institutions. This article shall be broadly construed to allow the inspection of government records. Let me pause just a second. Do you think that the money that's paid by a district attorney when she uses a no bid contract and gives one of those no bid contracts to her lover, paying him orders of magnitude more money than the assistant district attorneys, who are the full-time employees and criminal lawyers employed by the DA's office. Do you think that that is a type of expenditure of public money that the public would have some interest in? I think so. And I think that's why, this is all so relevant. They point out that the public policy behind the act is to encourage transparency in government. And I'm not going to go into all the case law they cite, but they point out that DA Willis has made public statements indicating that she would lead the DA's office with a stated goal of being transparent with the citizenry. The DA has denied plaintiff the right to inspect a number of Fulton County DA records. Some of these would include reports provided to the Fulton County DA by third-party media companies that were hired with taxpayer funds to track the impact of Ms. Willis' statements to the media and whether such statements were viewed favorably by the public. Ms. Willis first began contracting with these companies just immediately before the DA sought to investigate and indict Mr. Roman and the other co-defendants. Of course, Mr. Roman is Ashleigh Merchant's client, so that's why she speaks of him. But let me just take a time out here so what this is about, this piece of it. Willis went, when all of this started happening, we had the special purpose grand jury first. And of course, that generated a lot of media attention. And so they literally hired this company. They contracted with this company to monitor her media presence, to basically track how fast and how far and how high, I should say, her star was rising in the media. And so this was apparently something that was actively being tracked by not only Willis, but others in senior management there at the DA's office. Because after all, it's not just about getting Trump. It's about making sure that her star rises high enough, fast enough, because there's got to be something bigger in her political future. So she may as well start planning for it now. All right, back to the lawsuit. As more fully shown below, the DA is in clear violation of the act and appears to be intentionally withholding information in advance of scheduled evidentiary hearings in two separate proceedings. And here they're talking about the motion hearings on the motions to disqualify. This lawsuit was filed before that. We just haven't had any hearings on it yet, but the filing of this complaint was before the motion hearings on disqualification. Okay, it says that they appear to be intentionally withholding information in advance of scheduled evidentiary hearings in two separate proceedings and has forced the plaintiff to take action through this filing to obtain relief. These are not the efforts of an agency that values transparency, and the plaintiff requests that the court grant the relief requested and find that the DA must permit inspection and copying of numerous categories of documents that still have not been made available to the plaintiff. It is evident that the DA has withheld records without justification under the open record statute. We can skip talking about jurisdiction and venue, but it is important, like they stated here in paragraph 10, each of the records sought by plaintiff in this action is considered a public record. Okay? So we're not dealing with confidential things. We're not dealing with like Brian Steele's notes that they tried to snatch away from him in court the other day. We're talking about public records. They point out that the plaintiff is a Georgia corporation, and the defendant is the county and all of its agencies, et cetera, including the DA's office. All right, the factual background. And this is where, and look, I apologize if I'm going to do my best to not get too much into the weeds here. And it's not my intention to just read this stuff to you. You can read it on your own, but some of it is absolutely critical that to talk about it and to do it right. We got to dive in here. So she represents Michael Roman, who's one of the defendants, and the evidentiary hearing was scheduled for April 15th of 2024. On Mr. Roman's motion to dismiss the indictment and to disqualify the DA and the special prosecutor, Nathan Wade, from further prosecuting Mr. Roman in that case. Roman has asserted that Willis and Wade should be disqualified because Willis used taxpayer money to pay Wade, with whom she has had a romantic relationship at the time, and in turn has received financial benefits from such payments in the form of vacations, hotel stays, and other personal gifts. Roman believes that Willis' use of money budgeted to the DA is of utmost importance in evaluating whether Willis and Wade have an irreparable and fatal conflict of interest, and whether and to what extent Willis has otherwise used public monies for personal gain. In an effort to intentionally stall plaintiff's inspection of various categories of documents prior to the evidentiary hearing, the DA has refused, without adequate explanation, to provide the plaintiff with many of the requested materials that are known to exist. You see that? She says that she knows they exist. She's not just making this up. And she says that they're not subject to any exception to the act that would otherwise keep them from being something that had to be turned over under the open records laws. All right. And so in paragraph 19, they point out that all the way back in September, on September 1st, as a matter of fact, of 2023, Ashleigh Merchant requested certain public records from the Fulton DA's office. She used the Public Records Center electronic portal. Okay, this was some type of online system that Fulton County used, and it was assigned the various request number. The September 1st request sought any and all bids, contracts, or agreements for the appointment and payment of the following contractors: the law offices of Nathan Wade, Christopher Campbell, PC. That's a professional corporation, is what that stands for. The Cross Firm, LLC, Limited, LCC, I think it's supposed to be LLC, Limited Liability Company. Anna Cross, that's one of the other special prosecutors. Bondurant, Nixon, and Elmore, LLP, which is a law firm. And one Terrence Bradley. Most of these are people that we've talked about before, and you're probably familiar with them. She says here specifically, I am seeking their invoices, contracts, county approval of these vendors, and any other documents regarding the contracting and payment of these vendors. Plaintiff did not receive any documents within 3 business days. And by the way, that's what the Open Records Act requires, is that a response, be given within 3 business days. You don't have a lot of time if you're the government to sit on these things. And if you fail to comply with this, the open records law allows you to do just this: bring a lawsuit to try to deal with it. There were no legal exceptions asserted by Fulton County. So on September 7th, that's more than 3 days later, Ms. Merchant followed up to inquire when the documents would be available. She followed up again on September 11th, 13th, 14th, and 15th. Despite not providing numerous invoices and other documents in response to the September 1st request, or any reason for failing to do so, on September 17th, listen to this, guys, the county just closed the request without responding to it at all. They simply just closed the request. All right. So on January 24th, 2024, she had to refile her request for agreements and contracts set forth, the same thing she asked for September 1st. And by the way, if you need a flow chart, you're not alone. I mean, this is something else here, the obfuscation by the county. She refiled everything that she was asking for originally back in September. And it says they attached a copy of the September 1st request. This request also sought anything that was newly created since September 1st that would have been responsive to the request. Again, did not receive any response. So she followed up again on January 12th and January 16th, 2024. And she's getting close, by the way, to this looming, the big hearing, the one that we all watched, that was so dramatic that, when Fani Willis busted in like a wildcat with her tail on fire, demanding to testify after she had filed a motion to quash her subpoena, but I guess she gave up on it because she was mad that she was watching Nathan Wade be cross-examined. So she busted in so she could take the stand in that pink dress and call Ashleigh Merchant a liar. Yeah, that hearing. It had been now more than 3 months since the September 1st request. And on January 22nd, 2024, Fulton County responded that, quote, "Your request has been forwarded to the appropriate department and the time extended to accommodate the appropriate department." Now, mind you, I don't know that there's any basis in law for them to just unilaterally extend the time, but that's what the response was. "Please see attached letter. This request has been extended." Fulton County, once again, they closed the request. They closed the request again on January 29th and referred her to see the September 1st original request. In the footnote here, they point out that Fulton County's action in prematurely closing the request and forcing Ms. Merchant to refile the request under new request numbers made the request process unnecessarily confusing and burdensome. Yeah, you think? One can only assume this was done intentionally with the hope that Ms. Merchant would simply accept that the request had been closed and go away. Just move on. Thankfully, she did not, because it is evident that numerous additional responsive documents were, in fact, in possession of the Fulton DA's office and had not been provided. The open records process itself appears designed to I think they're referring to the process in Fulton County, appears designed to deter Georgia citizens from accessing public records, and it flies in the face of the transparency and the openness that the Open Records Act requires. All right, let me take a break to take a sip of water. Welcome to all the 3,482 people that are now in the live. I appreciate you being here inside the law, where we are taking a close look at the real justice system. And tonight we're doing it through the context of a lawsuit, the Open Records Act lawsuit filed by Ashleigh Merchant against the Fulton County government and the DA's office for allegedly stonewalling her while she was investigating all of the shenanigans that took place that we now know about between Fani Willis and Nathan Wade and the other cast of characters. But there's a lot of information in here, a lot of information. Do me a favor, hit the like button if you haven't already done it, and tell all your friends to subscribe, because we're pushing 45,000 is my next goal. Want to hit 45,000 subscribers, and I'm getting very close. And with your help, maybe we can do it soon. All right. Let's get back into this and see what else we can learn. On January 14th of 2023, Ashleigh Merchant had to file yet another request associated with the September 1st request, because the prior request had been prematurely closed. The new request had a different number. That request is attached also as Exhibit C. 4 days later, on January 18th, Fulton County responded, "Please log into the portal and see responsive document." That response provided only one contract for John Floyd, and then they closed the request. They closed it out. They did not provide any of the documents that were asked for, except for one contract for one of the other prosecutors, John Floyd. And then they just closed it. So finally, on January 29th, Fulton County wrote in the records portal with regard to the original. Now they're going back to the original September 1st request. And they say, "Please log into the portal to see the attached documents. See Exhibit A to this lawsuit." And they point out here that numerous documents were provided in this response, but numerous documents were still outstanding. To date, the following items remain outstanding under these requests, which have been pending for almost 5 months. 5 months. And the statute says you've got 3 days. And here they are 5 months later. And this was as of when this lawsuit was filed. That was 4 or 5 months ago. Invoices for July 2023 through December 2023 despite Nathan Wade having received payments for those months, invoices for Terrence Bradley, Anna Cross's current contract, as the contract provided to Ms. Merchant, had ended on June 30th, 2023. Current invoices for Anna Cross, her last invoices from October 2023. And John Floyd's current contract, the contract provided for Mr. Floyd, had ended in October 2022. So what they're doing is they're slow walking this in the extreme, and they're just giving her a little bit here and there, and in some cases maybe nothing, and just closing out these open records requests. All right, so here in paragraph 24, when a lawyer says upon information and belief, what the lawyer is saying is that they have a good faith basis for what they're about to say. And so the author of this complaint, by the way, is Ashleigh's husband, John Merchant. So what John is saying is that upon information and belief, he's got a good faith belief for stating that the documents sought in the September 1st, that's the original request, and all of the follow-up requests thereafter for the same documents were in fact in the possession of the DA. And he says they were intentionally withheld by the DA because the undersigned counsel filed a motion to disqualify Willis and Wade, and there has been considerable news coverage. You see where we're getting at? There have been considerable news coverage of the financial arrangements between Willis and Wade. As shown below, a letter from the Fulton County DA's office confirms that the stonewalling continues. And we'll get to that letter here in just a little bit. On September 15th, 2023, Ms. Merchant requested a different set of records from those sought in the September 1st request. So here we're looking at something different. Fulton County assigned this request a different number, so they're just going to call it the September 15th request, and it's attached to this lawsuit. And it was looking for copies of the monthly CARES Act reports for the DA's office, showing how the CARES Act money was spent. This is COVID relief stuff, right? COVID relief money we're talking about. They want records showing how the CARES Act money was spent each month. On September 19th, the DA responded, quote, "The Fulton County DA is in receipt of your open records request. However, after carefully reviewing your request, unfortunately, we do not have the responsive records." Now, does anybody believe that? Does that have the odor of mendacity itself? I mean, it's just everywhere. Upon information and belief, the DA and Willis are required by law to maintain records regarding the use of CARES Act monies received pursuant to federal ARPA grant funding. That's the American Rescue Plan. As a result, Fulton County DA and Willis should have records showing how those funds were spent. Nevertheless, and in addition to the other response, the DA responded, quote, in its normal course of business, they do not maintain responsive records. As such, we cannot produce the records you seek. Does anybody believe that? There's just no way that could possibly be true. January 8th, 2024. Another request. Ms. Merchant separately submitted the following through the Open Records portal. Quote, "I am seeking personnel records. I am requesting a list of all attorneys with their names and their dates of hiring that were hired by the DA since Ms. Willis became DA, including the date hired." Now, before I go any further, a lot of you people may have worked in human resources at some point in your life. If not, you've interacted with human resources. You've had jobs. You've hired people. You know good and well when you hire an employee, particularly if you're going to work for the government, there is records of that hiring. There's records of payroll. There's records of resumes. There's all kinds of records that are associated with hiring of personnel. And when you're talking about looking at 2 or 3 years at the largest DA's office in the state of Georgia, you know they've got personnel records, don't you? They have to. They have to. All right, don't forget to hit the like button. All right, here we go. Let's see what they have to say about that. So 10 days later, on January 18th, the DA responded, Please log into the portal to see responsive letter. No responsive records. No responsive records. This office, in its normal course of business, does not maintain responsive records. As such, we cannot produce the records that you seek. They're saying that they don't keep records of the people that they hire. Unbelievable. Unbelievable. This request was sent because Willis had made a presentation to the Fulton County Board of Commissioners in 2021. She made a big production, guys. She had a PowerPoint and everything talking about how she needed all this money from all this COVID relief money, by the way, to clear up the backlog. She had to hire all these new people to clear up the COVID backlog. And the idea of what they're getting at here is that instead of using it to hire personnel to clear up the COVID backlog, they're using it to fund this racketeering case and this racketeering investigation and paying Nathan Wade and so on and so forth. So this request was sent because Willis made a presentation to the Fulton County Board of Commissioners asking for additional funding to hire lawyers and staff to assist in the clearing of the backlog of cases due to the COVID pandemic. If that was true in 2021 and Miss Willis did indeed hire lawyers and staff with the funding granted to her, there should be records relating to the new hires over the past 3 years. Well, of course there should be. Of course there are. So on January 8th, 2024, another request says Ms. Merchant requested a copy of any and all documents, agreements, contracts, memos, written documents that employees, staff, or independent contractors of the DA's office have been required to sign regarding speaking to the media and or confidentiality. We're talking about non-disclosure agreements, otherwise known as hush money agreements. On January 9th, 2024, Fulton County acknowledged receipt of this second January 8th request, but then responded 10 days later, of course, which is well beyond 3 days as the law requires. Here's the response. Please allow 10 business days for a response. To date, Ms. Merchant has not received any further response through the portal, but on January 26th, the DA's office said, in the normal course of business, we do not maintain responsive records. As such, we cannot produce the records you seek. Just unbelievable. Absolutely unbelievable. Upon information and belief, the DA issued a statement to the news media that the NDAs did exist, but they were later retracted. So the DA issued a statement that the hush money contracts did exist. All right. On January 9th, 2024, another request. Ms. Merchant sought, quote, a copy of any and all correspondence to and from, correspondence to and or from vendor Critical Mention Incorporated. Critical Mention Incorporated is the media monitoring company. At the beginning of this live stream, we were talking about Ms. Willis, and she had hired this media monitoring company to monitor how high and how fast her media star was rising. Okay. They paid tens of thousands of taxpayer dollars for this purpose. And they started paying them just before this RICO case started. So it's all coming together that this was some kind of coordinated plan that she was going to work the media angle just as much as she possibly could to try to get the very best possible press, because she knew this was going to make a splash in the media. So Ashleigh's trying to get correspondence from to and or from vendor Critical Mention Incorporated, including copies of contracts or payments and all analytics and or reports from Critical Mention to any member of the DA's office. So she's wanting the contract, she's wanting the payments made to Critical Mention, and she's wanting the reports that Critical Mention provided to the DA's office showing how high and how fast Fani Willis's star was rising. So that's what that's all about. And on January 12th, 2024, she made clear she was asking for, quote, the analytics that were provided by Critical Mention. The contract is for media monitoring, and analytical reports are provided in response to this contract. And we asked in our open records request for those as well. On January 18th, 10 days after the original request, the DA provided some emails that make it clear that the DA used funds to contract with Critical Mention to monitor the media presence of Willis. Those emails contained attachments, which were the very reports that they were looking for. But guess what? The reports were not provided, simply the emails, but not the attachments. And then guess what? They closed the request before it was fulfilled. So, like before I get into paragraph 29, so like one thing that I do, and welcome to the 4,300 people that are in here live now. I really, really am grateful that you chose to spend some part of your weekend, your Father's Day weekend with us here inside the law as we break down this open records lawsuit. With regard to this media monitoring situation, so like, for example, with this channel of mine with Inside the Law, I have certain reports that I can look at. I can see the analytics. I can see the metrics. I can see what's working, what's not working, and I use it to make changes to hopefully bring you a better product. And by the way, if you like the product, feel free to support the product. There's links in the description, but you can also just simply hit the like button. But I use these analytics to try to do better every time and to try to not repeat something that's not working, or to try to repeat something that is working. And so they were doing the same thing here with this media monitoring company. They wanted to see what Willis was doing that went well, what didn't go so well, so that she could, again, make sure her star would rise as high and fast as possible, using taxpayer money to do it. That's what it's all about. Okay. 29. As a result, this forced Ms. Merchant on January 18th, 2024 to refile the January 9th request. The refiled January 9th request is attached to this lawsuit. She specifically states that she sought, quote, the analytics and documents that are clearly referenced and attached to those emails. She also noted that it appears from the emails that Jeff DeSantis, Fani Willis, Jeremy Murray, and Pallavi Perkayasha, I'm sure I mangled that, or Robin Bryant and Rita Kepler may all have accessed those reports on a regular basis. These reports are of public media and are paid for by public funds and subject to open records. The DA responded by stating, as it relates to the records you seek, this office, in its normal course of business, does not maintain responsive records. As such, we cannot produce the records you seek. As it relates to your request to view electronic communications, your request as written is not reasonably calculated to locate the records you seek. Does that sound like a bunch of gobbledygook? It is. And by the way, they're literally saying they can't produce the records you seek because they don't maintain those records, even though they've already provided her the emails showing that they have the records, showing that they actually have the records. It's the blind leading the blind. And it's so dishonest. It's just stunning. Since the Fulton County DA provided the emails that contain the attachments, the emails and the attachments are, well, that's what I just said. They're obviously kept in the ordinary course of the DA's business, so it's not clear why the attachments and other responsive materials have not been provided. Also, Ms. Merchant has never requested to view electronic communications, so the basis for withholding the documents is without merit, appears designed to keep Ms. Merchant and the public from seeing the contents of the reports and other data provided by Critical Mention. Neither Fulton County DA nor the Fulton County itself provided any legal objection to producing the requested documents within 3 business days as required by law, so they have waived any right to withhold the documents on any stated basis. Merchant resubmitted open records requests the January 14th request, which sought any and all contracts, agreements, vendor documents, communications between any county entity and a vendor called TV Eyes Incorporated. TV Eyes Incorporated is another company that provides analytics similar to Critical Mention. So in response to that, they finally said, your request is being reassigned to the district attorney's office for response. I mean, is this just the runaround? I mean, she's literally getting the runaround from everybody at every turn. On January 25th of 24, the county stated, please log into the portal to review the letter attached. And it says, this request has been extended. Neither Fulton County nor the DA has ever provided any documents in response to the January 14th request. So this request remains outstanding, even though it's now several weeks old. Remember, folks, the law says they've got to provide these records within 3 business days. 3 business days. You know, it ought to be a crime, by the way, to violate Open Records Act in such a way. On January 16th, 2024, Ms. Merchant submitted open records requests, which requested a copy of any and all vacation. Here we go. Vacation or time off requests for Fani Willis from January 1st, 2022 until the current day. Merchant was told that it would take 10 business days. Therefore, responsive documents should have been provided by, according to that timeline, January 26th. However, on January 26th, the DA's office said, in its normal course of business, does not maintain responsive records. As such, we cannot produce the records you seek. Gobbledygook. More of it. Gobbledygook. On January 16th, 2024 at 1:26 p.m., Ms. Merchant requested open records request number so-and-so reports. She was looking for reports and itemization that was required by law to be submitted to the county as the local governing authority, showing what was done with, this is important, all property and funds obtained through asset forfeiture, including reports showing where the funds were spent and who was paid. Yes, it is very true. They have to keep up with that stuff. They have to account for it to the penny. On January 26, 2024, 10 days after the request was submitted, the DA responded that responsive records are attached. And they noted that we believe that you're seeking the office's equitable sharing agreement and certificate. Nope, that's not what she was looking for. So they gave her the wrong stuff. They gave her some document she didn't ask for, and they pretended to have complied with it. Ms. Merchant was not seeking the equitable sharing agreement, but was instead seeking records of the forfeiture fund, accounting for the funds used to pay independent contractors Nathan Wade and Anna Cross. See, they're paying Wade and Cross, according to this lawsuit, out of seized asset forfeiture funds, and that could be a problem. Wade was paid on July 15th, 2022, August 12th, 2022, September 23rd, 2022 from unit name Confiscated Funds. The fund was seized property dash law enforcement under code 440. Cross was also paid out of the same fund on 2 different dates. The DA has not provided any further documentation in connection with the first January 16th request. You see where this is going, folks? I got to have another sip of water before I continue reading. Look, this is what we're seeing here is we are seeing just obfuscation after probably lie after another obfuscation after another lie, all designed purposely, I think, to keep her from finding out the truth about all this. Now, remember, what is the base? If you look at this racketeering RICO case, what is the basis for it? Really, at its very heart, she's alleging that people, Donald Trump and others, made false claims, and that at the core of this racketeering case is false claims about the election. Okay, and notwithstanding the probable likely, definitely 100% certain false testimony that was given in court and the odor of mendacity, we probably have some false statements made here in connection with these open records requests. I mean, the hypocrisy knows no bounds. All right. Let's see. January 17th, merchant requested copies of travel reimbursements, requests for reimbursements, communications regarding and proof of reimbursements for Fani Willis for the purpose of period 2020 through the present. On January 26th, the DA's office responded that in its normal course of business does not maintain responsive records. As such, we cannot produce the records you seek. All right. So on January 17th, 2024, she asked for any and all correspondence communication between purchasing and the DA's office. That would be the county purchasing office and the DA's office for 2021 until the present regarding outside counsel. That's Wade, including payments, requests for payments, and the process for hiring and bids, if any. Of course, we now know this is all no bid contract. And basically, she wanted documents dealing with the process for hiring and paying outside counsel. Merchant specifically referenced this to include, quote, the referenced retraining of the district attorney, retaining of the district attorney by purchasing that was discussed during the Board of Commissioners meeting. I take that back. It was retraining. Ms. Merchant specifically requested this to include the referenced retraining of the DA by purchasing department that was discussed during the Board of Commissioners meeting in November 2023. Again, the response: in the normal course of business does not maintain responsive records. As such, we cannot produce the records you seek. It's like a broken record down there. In January of 2024, in order to summarize all of the outstanding pending requests, missing documents, and materials, Ashleigh Merchant sent a letter to both Fulton County and the DA asking that all pending requests please be resolved and documents produced by the close of business on January 26, 2024. Apparently, in response, the DA sent its January 26 letter, but failed nonetheless to provide most of the requested documents. At no time prior to 3 business days following receipt of any of the above requests did the DA raise any legal objection, cite any exception that would apply for failing to provide the requested documents, or otherwise provide justification for failing to provide responsive documents. And here we go into the specific counts of the lawsuit now in the Open Records Act. Again, they point out all public records shall be open for personal inspection, inspection and copying, except those by which by order of a court of the state or by law are specifically exempted from disclosure. And again, they never cited any legal exemption from disclosure. Agencies, under the law, the agencies shall, doesn't say may, it says shall produce for inspection all records responsive to the request within a reasonable amount of time, but not to exceed 3 business days. Can you see how far outside the bounds of the law the DA's office is here? I mean, we are not anywhere close to being in compliance with this statute. I'll skip down here, paragraph 43. Says an agency's use of electronic record keeping systems must not erode the public's right of access to records under the Act. Agencies shall produce electronic copies of, or if the requester prefers, printouts of electronic records or data from database fields that the agency maintains using computer programs that the agency has in its possession. Defendant has failed to properly and timely respond to the plaintiff's request under the Open Records Act. None of the records sought from the defendant are subject to any exception. Defendant has refused to provide plaintiff access to those records for an unreasonable amount of time and without a proper legal basis. Defendant has no legal basis to withhold responsive documents. Defendant is acting intentionally and in an effort to hide from public view documents showing how the Fulton County DA has spent public monies related to the operation of the office of the Fulton County DA. Defendant is in possession of additional documents and materials that are responsive and which are not subject to any exception, but nonetheless have not been produced. Defendant has acted in violation of the act without justification and continues to act in violation of the act without justification and will continue to act in violation of the law unless the court intervenes to compel defendant's compliance. So the plaintiff's asking the court for an order compelling the DA to produce all the records for an in-camera, that means in-chambers inspection, and to appear before the court and show cause why the requested relief should not be granted instanter. That means immediately. Now, the exhibits to this it's basically copies of the I guess printouts from their portal that you can see where it says status here. Look at this one. This is the first one, like complete records released, when of course we know that they weren't. But there's a letter that I think is important. We don't have to go through all of these emails. But there's a letter that they reference here. We got more, just copies of the open records request. There's a letter dated January 22nd. Oh, that's not the one I'm looking for. Bear with me. I highlighted it, so I'll know it when I get to it. I just didn't think we needed to go through every page of all of these exhibits. All right, so here we go. January 26, 2024. The office of the Fulton DA has received your letter dated August 24th. Well, that can't be right, because the letter was written January 26, 2024. They must mean January 20. So it's a typo. The office of the DA has received your letter dated what looks like it should be January 24th, 2024. Despite consistent communication, you imply that this office has failed to meet its obligation under Georgia's Open Records Act. No, I don't think they're implying anything. I think they're outright saying it. We respectfully disagree with your disingenuous implication. They're calling her a liar again. As you're aware, the Open Records Act requires a public entity to make county records available for inspection, et cetera, and so forth. They summarize the responses basically that we just went through that were part of this lawsuit that really were not proper responses. See, like, for example, they refer to their response here that Fulton County District Attorney, in its normal course of business, does not maintain responsive records. As such, we cannot produce the records that you seek. Speaking of records, they're like a broken one. Always the same thing. Always the same. And then I thought there was somebody was going to have the wherewithal to sign this, but they just said, sincerely, Open Records. Doesn't even have a person's name on it. They want to call her a liar, but don't even have the decency to put a name to that letter. They do at the top of the letter, though. It does have Fani Willis's name, so she's ultimately responsible for all of this. That's it. That's the backstory. And we know that Ashleigh Merchant nevertheless got a lot of the information she was looking for, because she, of course, had a great hearing series of hearings, I guess, that led to the odor of mendacity order that said that Willis had acted improperly, but that she didn't have to completely recuse her office if she would just let Nathan Wade go. And of course, that's the issue that's up on appeal. Now, I have not been able to look at this chat since I've been going. That was in another screen. if any of you have any questions that I can answer, I'm going to go ahead and start looking at them. Thank you for thank you, Texan, for reminding folks, please hit that like button. There's 4,600 people in here. Go ahead and hit the like button. It'll help other people find this channel, Inside the Law, where we explore the real justice system versus what you may think we have. Here's a question. Does Georgia have record retention laws concerning government records? Yes, they do. I'm not an expert in it, so that's as deep as I'm going to go. I can't answer it more than that. There's probably people in this chat that are better experts, and they might give an answer better than I can give you. All right, so let's see. Misty posted something on X today, and I think it was in response to something I posted. You shared some screenshots, Misty, that were very similar to the exhibits to this lawsuit that showed, in your own experience, how Fulton County was stubborn in not properly responding to open records in your own experience. So I appreciate that. What are the fees for public records? I wish of course you asked me that. If you hadn't asked me, I probably could have told you. I do know that it's so much per page. Maybe it's 25 cents a page. And if it gets to the point of X number of dollars, I think they've got to make the requester aware of what the dollar figure is going to be to see if they really want it, or do they maybe want to narrow the scope of it a little bit. I've done some open records requests for personnel records of government employees that were really, really expensive, like in the thousands of dollars, because there's so much paper. So there is a statutory limit on it, and big ones can get fairly expensive. All right. I wanted to say, by the way, thanks to Bucky Badger for being a new member, and thanks to Jen Lee for gifting the Inside the Law memberships. It's this kind of support, and the super chats and the super thanks, if people are watching it on replay, and folks exercising by the links that are in the show descriptions, that kind of support really means a lot, and it helps me to continue to bring better and new and additional good, I think, content to the channel. So I wanted to just say thank you very much for that support. All right. Kate points out no fee if it's part of discovery. Well, that's true, but they were using the Open Records Act and not discovery, because they don't always cover the same thing. There is some overlap, but in this case, they were clearly pursuing this information not through Georgia's criminal discovery statute, but through the open records law. All right, let's see. I know I saw. See, when I see the word question at the beginning, it helps me identify it as something I want to perhaps look at. How long Kathy asked, can they continue to commit these crimes and cover ups for someone not stepping in to stop it? Well, I'm not going to go so far as to say they've committed a crime in violating the open records law, but your point is well taken. And that's what this lawsuit seeks to do. It seeks to hold them accountable. And there is a hearing on June 25th that should be live streamed. Jennifer, thank you very much for that. And like I said, the super chats mean a lot. Thank you so much. The hearing should be live streamed. In fact, I believe the hearing is going to be on Zoom. It's not like an in-person hearing. It's going to be on Zoom, and I am told that it's going to be streamed. Okay. Thank you for joining, Kenneth. I really appreciate that. And happy Father's Day to you, Cindy. Thank you very much. And hope all of you had some, regardless of Father's Day, I hope you all enjoy some time this weekend with your family. Question: can you use the open records procedure to obtain information that is not normally available through discovery? Yes. I don't know about Texas, which is where you say you've got a pending case in Texas. But yeah, the answer is that because there are some things that they don't have to give you. They don't want to give you. They may not be obligated. Georgia's criminal discovery statute. Now, look, I'm going off on a tangent here and getting up on my high horse, because Georgia's criminal discovery statute is terribly insufficient. So, like, if you run a red light and you wreck your car and somebody sues you for running that red light and wrecking your car, and they claim that they've got bodily injury and everything else, you know what they can do? You can have depositions. You can get anybody and everybody who might be a witness. You can get them to come to your office or to some other place, and you can put them under oath with a court reporter, and you can have depositions, and you can ask questions. You can make them talk to you about what they know about the case, whether they're going to be a trial witness or not. And you can make them produce records and documents. You can make them answer questions under oath. It's called written interrogatories. And so if the only thing that's at stake in the state of Georgia is money, and it's usually not even your money, it's usually the insurance company's money. But if that's all that's at stake, your lawyer can find out almost anything and everything through a just vast civil discovery. But if your life is on the line, or your freedom because you've been charged with DUI or murder or RICO or shoplifting or possession of marijuana, or you name it, anything like that, you don't get to have depositions pre-trial. You don't get to, if a witness doesn't want to talk to you, you can say, beat it, Holloway, I don't want to talk to you. I have no recourse. I may not know what that witness is going to say until they take the witness stand at my client's trial. So we have no real meaningful discovery in the state of Georgia. And to the extent that we do have it, there's a lot of things that prosecutors are required to hand over, but you're sort of at their mercy. And I'm not saying that they're all dishonest, but but sometimes things get left out accidentally, and sometimes they get left out on purpose. We are at the mercy of the DAs to provide all the discovery and to provide the information. And so a lot of times we resort to other ways of finding out information. One of the tools that we have at our disposal, since we don't have the civil discovery that we have, that other states have in criminal cases, but because we don't have the kind of discovery rules and mechanisms in criminal cases that we do in civil cases, we use things like this, the open records law, to get what we need. Darkborn: Fani is running the Fulton DA's office like a racketeering organization. Why has the state or feds not stepped in to stop it? Well, I think you probably know the answer. Do you really think that the U.S. Attorney's Office is, in the current DOJ, is going to come in to do anything about this? No, of course not. And it's very impractical. There's nothing the governor can do in Georgia. He doesn't have any power, to step in. Theoretically, if the attorney general thought that there was a crime, or someone at the AG's office, I guess, thought that there was a crime, they could perhaps get another state agency to open up a criminal investigation. But that's going to take a long time. And there are other concerns that go with that. It makes it very, very difficult. So we are left, unfortunately, with a patchwork of partial remedies here and there, just one of which is being pursued by Ashleigh Merchant through this lawsuit against the county for the open records violation. But thank you for the super chat, and thank you for the comment and the good question as well. All right, let's see. I know I saw some other questions. Happy Father's Day to you as well. Okay. Yeah. Kenneth points out that the minimum retention to records is 20 years. Punishment for failure to respond to the FOIA. Pay all attorneys and other costs. Well, see, there are lots of experts in many different fields that I find in these chats, and lots of people know a lot of things about stuff that I don't even know about, and which is not saying much. I don't claim to know a lot about everything, but I do appreciate it when people who are knowledgeable weigh in the chat. It helps the show a lot. What can we, the people, do? It feels so hopeless. Well, at a minimum, you can vote. You can go to the polls and you can vote for people who are honest and have integrity and who are not going to weaponize the legal system. You can pay attention, just like you are, to you can pay attention to current events like you are, and you can spread the word. You can do your civic duty by getting out and preparing, helping politicians. Send Courtney Kramer some money. She's running against Fani Willis as the Republican nominee. Send her some money. She'd love to have it. And, that campaign or that election is going to be in November. Who knows what could happen between here and then? I mean, we at the beginning of the show, let me see if I can pull this back up. At the beginning of the show, I showed you guys, and for those of you who weren't here, I think it's worth pointing this out again. I want to show you what Fani Willis is doing today in terms of fundraising. Okay, so let me just see if I can share this screen with you again, in case you missed it the first time. Okay, this is what Willis did today. That somebody got this as a text. She says, "This is Fulton County DA Willis, Fani Willis, and I just said something I need to get off my chest. Too often in America, Black women, especially those of us put into positions of power by the people, are attacked and over-sexualized for doing the job we were elected to do. As I continue to do my job and seek re-election in 2024 as Fulton County District Attorney amid disingenuous attacks from the right-wing media, harassment, and regular death threats, I do sometimes stop and wonder, would all of this abuse and vitriol be coming my way if I were a white man? I need to know, can I count on you to help me stand up to these daily attacks in my re-election fight against a right-wing opponent? If you will stand with me and stand in solidarity with Black women in positions of power, please donate any amount here." And so, the question that I posed on X is, how much hubris does it take for Fani Willis to say that she is over-sexualized after what we know she did? I just don't understand that. Maybe you guys understand it. I certainly do not. Thanks, Senior Chief, for gifting the memberships. That's awesome. Thank you so much for your continued support of the channel. But somebody sent that to me, and I'm just like, I cannot believe it. This is what her campaign's about. She can't campaign about the issues that are important to people in Fulton County, such as the fact that you're likely to get shot at any given gas station at any given day in Atlanta when you're just there trying to get gas. Home invasion, armed robberies, gang violence, it's all through the roof. And she's done little to nothing to stop any of that. So she can't campaign on that record. That much is true. All she can campaign on is playing the victim here, playing the victim. All right. I skipped. I know there was some questions and I saw them and I couldn't get to them in time. Here's one. How does the Georgia Election Board findings of fraud and irregularities affect this case? Jill, that's a great question. And what I need to do is I need to have attorney Chris Kacheroff back here inside the law as my guest. He represents Harrison Floyd. I did one video with him about Harrison Floyd's case. It's been a few months back, but there's nobody. Chris and I talk offline a lot. There's nobody better than him that understands that piece of this. I need to get him back, and I plan to do it because a big part of his defense in the case is that when they made these claims, they weren't lying. Okay. In other words, he aims to prove that there were, in fact, irregularities, perhaps even fraud. I don't want to speak for him. I want him to come in here and speak for himself. But that's essentially where he's going, and nobody can articulate it as well as he can. Thank you for the question. Thank you, George. Appreciate that very much. Kenneth's a retired police officer from Clayton County with 40 years of service. Thank you for those 40 years of service, Kenneth. You're very familiar with the corruption of Fulton, but you're also familiar, Kenneth, with corruption in Clayton County because you said you were a police officer. Well, Clayton County, you must have worked there as a police officer at some point during either of Victor Hill's terms as sheriff. And that, I should do an entire show about the former sheriff of Clayton County, Victor Hill, who went to federal prison for, among other things, abusing an inmate and all kinds of stuff. Anyway, thank you for your service, Kenneth, and thank you, of course, for the super chat. How do you declare a request closed without producing? That's an excellent question, Edwin. I mean, it doesn't make any sense, but that's what they do. Victor, now see, we're having there's 3,600 people in here, most of whom don't know that we're having an inside conversation here because, we called him Walking Small. Okay, because we just did. We called him Walking Small. He was the former sheriff of Clayton County, that classic Napoleon complex. But Google Victor Hill, and you'll find a lot to. Kenneth's very familiar with Victor and others. That's true. He had a lot of folks around him. Maybe that gives me an idea. Maybe I'll do a show on Victor Hill. Kenneth, maybe you can come in and be my guest, and we can do a show on Victor Hill. All right. Look, folks, I don't know what's going to happen at this hearing coming up in. I don't know what's going to happen at this hearing coming up on the 25th of June. I do believe it's going to be live streamed, and I do believe it's going to be something that you'll all be able to see. I'm not going to be able to share it with you because I am going to be at the Fortress of Solitude in parts unknown and undeclared for, some period of time that's inclusive of the date of June the 25th. Thank you very much, Edwin Jones. Much appreciated. But I'm going to be following it, and who knows, we might see some short videos popping up from the Fortress of Solitude or somewhere in the general vicinity. Speaking of which, there's another thing that I'm going to start doing is these, like we've been talking now an hour and 15 minutes, and we've gone over a lot. But there are some people who watch this on replay, and they may not have an hour and 15 minutes, but they still want to figure out what's going on. So what we're going to start doing is we're going to start breaking some of these live streams down into smaller, more easily consumable formats. Like earlier today, I posted a 12-minute video that was a short summary of why the trial judge needs to be recused from the Young Thug case. And it was part of a live stream we did the other day. And so you might see me being able to post some things like that. I might be able to do some shorts. I'm considering also doing some streaming on maybe other platforms, maybe TikTok even. Not there yet, but thinking about it. And that might be an opportunity to do smaller, shorter kind of things when we don't have time for a full live show like this one. But in any event, look for that going forward in the future, because if you can't be here, and I love talking to you guys and hearing from you, but if you can't be here for an entire live stream, which usually go anywhere from an hour, sometimes 2 hours, but if you just want to get the basics, the main parts of it, I've found someone who's a professional editor, and I am not tech savvy at all. So when we see these super chats like Kenneth and Edwin and so many of the others, that's what this goes to help me do. I'm every dime of that's going to go to paying an editor. But it does help other people and have access to the channel, people who don't have the time to watch the entire live feed. So thanks for all of that. So just be on the lookout. These are some things. And look, I told you that I read the comments. I go back and I look at these live streams, and I keep, unless I have to edit something out in some way, I will keep the live chat. It's going to be like you can see the live chat replay. I've not been able to monitor the live chat as much as I would like to. Wait a minute. That one says, I am not a podcaster. I'll tell you about that in a minute. But I will go back and I'll watch these things, and I'll try to take suggestions. I look at comments and I try to sort of adapt and maybe make changes here and there to provide a better product. So the shirt says I'm not a podcaster because I got this at a gathering called Podcast Movement. You may have heard of it. The idea is that we were calling ourselves storytellers and not podcasters, even though we were in fact podcasters. So I wear it tonight because people will say, well, I love your podcast. And this is kind of like a video podcast. So it's just I think it's just kind of fun to point out that I'm not a podcaster. We are a storyteller. In here, my point in doing all this is not to tell a story, but it's to bring you inside the system as I know it to be. All right. Well, that's about all that I have got for you, unless there's any burning questions. Well, here's one right here. Don't go away yet. Okay. Well, where did it go? Question. There it is. How many people die in the Fulton County Jail? And what is the most common form of death at the jail? Well, Rob, we did one of our Fulton Follies and one of the topics of that show was deaths at the jail. And Rachel Kaufman came in here with me, and we talked about there was one instance where a person had been jailed without bond, or with a bond he couldn't make, and it was just like a misdemeanor, but he didn't make it out alive because he got eaten in the Fulton County Jail by bed bugs. And then, of course, you get a lot of people that are stabbed down there. There's suicides. I don't know the answer to what your question is, what's the most common form of death, but I do know that death is unfortunately way too common at the Fulton County Jail. It is literally a death trap. And it's something that's in the news, frequently here in the metro Atlanta area. And it's something that we have talked about here inside the law as well. But it's a particularly bad jail. There's an ongoing political debate about whether the county is going to pony up money to build a new facility, and it's most definitely is needed, and it's going to be very expensive. The county doesn't seem to want to necessarily go ahead and write that check just now because they're concerned about how, if they that's my dog. Hey, Winston. Okay, now that he's finished, there's the concern is, why write all that, spend all that money if it's going to be managed perhaps in the same way? And that's sort of the reluctance in having them get started. So this is kind of a wait and see thing, but it's a big deal here in Atlanta and something we're all watching very carefully. All right. Yeah, that was Winston, who right there behind my shoulder. That's Winston. He's been laying down here at my feet. And of course, someone came in the door, and if a leaf blows and falls on the roof, he will hear it and he will bark just like that. But if somebody breaks in, he's going to do that, but then he's going to go and probably lick them, maybe to death, but he's not. He's just an alert dog. All right. Tammy, I would show him to you if I could, but he's gone. He left the room and ran to the door. All right. Before we go, we are still watching very closely the Young Thug case, and we are watching almost on a daily basis all of the shenanigans that go on there. And we're going to be watching that again. They're supposed to start back Monday. We got Monday and Tuesday, and then Wednesday's the Juneteenth holiday. And then we'll see what happens in the days to come. But let's not forget that this is the kind of witness that Fani Willis thinks needs to come and testify at a racketeering trial.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lies.
Yes, you may. We're gonna take a break. Hang in there.
The man, the judge wants to hold Brian Steele in contempt, throw him in jail for daring to question the judge on having an improper ex parte communication and refusing to tell the judge how he got the information. But this guy can come and testify that way, which is contemptuous as hell, and nothing at all happens. And nothing at all happens to the prosecutor who called that person who's intoxicated, calls him as a witness. But anyway, before I get up on my high horse, thank you all for being here, and we will see you next time right here inside the law.